Hi, this is Gauri Moliki from People for Animals. Welcome back to Ahimsa Matters. Rescuing an animal is an emotionally exhausting exercise. Sometimes, in our effort to take the animal to safety and to provide it with the treatment and shelter, we omit following the necessary procedures for custody. This later can become a big problem and the custody of the animals can be taken away from us. So let's understand today how to obtain custody of animals after you have rescued them. So if a cruelty matter has been reported to the police and the police has filed an FIR or an NCR and has seized the animals, they are required to produce these animals before a magistrate within 24 hours of such seizure. After going through the process of identification and health checkup, the details of these animals are then produced before the magistrate of the jurisdiction. At that time, the magistrate decides, under Rule 3B of the Case Property Animals Rules 2017, who to give the animals to. The choices for the magistrate are given in Rule 3B of the Case Property Animals Rules. The choices are SPCA, Animal Welfare Organization, Gaushala, Pinjra Pool, Kanji House, or whatever. Besides that, the magistrate may consider other options as well, provided somebody files a custody application. So, rescuing an animal from a situation is not enough. Giving a written complaint to the police, ensuring that the process of seizure is followed, and then filing for a custody application before the magistrate within 24 hours to get the custody of the animal is very important. The police, mind you, cannot give the custody of the animal to any person. Only a magistrate has the power to grant custody. Sometimes there are a large number of animals and the police wants to get rid of them quickly from the police station, so they might send them off to an animal welfare organization, but that does not mean custody has been granted. Custody would still have to be decided by the magistrate. If you are not the complainant and the police has rescued some animals on their own, seized them and have brought them to your shelter, you would still need to go and ask for custody from the magistrate if you want to keep them for longer. Custody application is a simple application which can be filed in the Judicial Magistrates Court in the district. It should contain your organization's credentials and what facilities you would have or you would be able to provide in order to keep these animals safe. These animals, remember, will be property of the court and will only be in your custody temporarily till the discretion of the court. You must include in the custody application why the animal should not be given back to the accused. It could include his character, because of which the animal would be subject to unnecessary pain and suffering if it continues to be with him, or the nature of his trade, or any of his past records. If you read section 29, it would be clear to you that the person who has been cruel to animals, if it is demonstrated to the magistrate that he would continue to be cruel to animals, then he may not get the custody back again. But for that, the custodian who is proposing to take the custody should put those facts before the magistrate within 24 hours, mind you, of the seizure. Please do remember that even when you get the custody, you are simply the custodian of the animal and not the owner. The animal would remain property of the court till the pendency of the trial. So good luck to all of you for more successful rescues and keep watching this space for more videos.